Mr Speaker, we will be supporting this legislation with those reservations.
Mr Speaker.
Keith Locke.
Thank you, Mr Speaker. I wasn't going to give another speech in this House after my valedictory last Wednesday, but I've finally been persuaded by the argument that because I was the Green representative on the Select Committee hearing the video surveillance bill, that I do have a duty to speak on the committee's report back to the House. The Greens support most of the changes the Select Committee made to the original bill, those that were for the better, but we still cannot support the bill. We particularly thank those who submitted to the committee, who inspired many of the changes for the better. I must congratulate the 438 people and organisations who submitted written submissions and the 20 who spoke before the committee, all in 2 days after the bill was tabled in the House. This level of concern, almost all submissions opposed the bill, is another reason why this bill should not have been rushed through the House in a week. What we are making here is rush law, which is bad law and also a necessary law. Here is a temporary measures bill in an area where there is no demonstrated need for temporary measures. It is legislation in search of a real problem. It also threatens the rule of law. The rule of law requires us to respect the law. This is a sorry saga of disrespect for the law and the courts. First, the police in the Operation 8 case deliberately break the law by putting a video camera on private land, not trying to get a warrant to do this because, as the Chief Justice said, they knew they couldn't lawfully get one. Ruling on this case, the Supreme Court on 2 September says that the use of covert video surveillance involving trespass is unlawful. As a result, charges against 13 of the Operation 8 defendants are dismissed. This upsets the government, but instead of accepting the verdict, it rushes through a bill to override the general impact of this judgment and also make the new law retrospective. The government then scaremongered by claiming that all kinds of investigations and court cases would be effective. But when I and others interrogated this at the Select Committee, it was found to be incorrect. Rodney Harrison QC said that there had been that if there had been court cases where the police had been using search warrants to authorise camera surveillance involving trespass, those cases would have come to the attention of criminal lawyers, and he doubted that the police had been doing this. The Law Commission thought there had been, quote, 1 or 2 court cases that dealt with trespassery video surveillance. It is common sense that most surveillance cameras have been those used to check the comings and goings to a property through cameras in the street or with permission from a neighbouring property. None of these cameras were ruled unlawful by the September Supreme Court decision. Of course, their operation would have to meet the test of reasonableness, meaning that they did not, in the circumstances, unreasonably intrude on the privacy of people as guaranteed by Section 21 of the Bill of Rights Act. So what was the video surveillance bill all about? Whether there was any conscious intention or not, it was about the state flexing its muscles, particularly against the courts. The Supreme Court clarified the law in a way the government didn't like, so what was the government's response? We'll simply change the law immediately. The government seems quite happy that this bill will give a range of state agencies with search powers, the police, fisheries, customs, internal affairs, etc., pretty much untrammelled powers to use covert video surveillance. If the surveillance is over-the-fence surveillance, a warrant will not be required. If it involves trespass, there needs to be a warrant, except that the warrant does not need to specify that there will be any surveillance, just that the property will be searched. All these state agencies are now able to leave a hidden camera behind after their search. Yes, there has been a concession in that some of the retrospectivity in the bill has been removed, and that's good. The bill no longer blankly validates all video surveillance in the past. All the arguments from the police, etc., about the practical need for retrospectivity collapsed. But it is still bad and unacceptable to the Greens that the revised bill gives a free rein to use video surveillance to a range of state agencies for 6 months into the future. To make matters worse, a new bad retrospective clause has been added. That is Clause 5A, which denies a convicted person the right to use their appeal in their appeal the fact, following the Supreme Court decision, that covert video surveillance involving trespass is unlawful. This is constitutionally repugnant, being contrary to the New Zealand Bill of Rights Act sections 21 to 28 inclusive, which deal with search and seizure and the rights of accused persons. It is a fundamental principle of law that people engaged in court proceedings have the right to access the law as it applied at the time of the alleged offence. And I will be moving an amendment to delete clause 5A. If my amendment fails, then the application of this retrospective clause could easily be challenged at the UN Human Rights Committee as in contravention to the International Covenant on Civil and Political Rights, which prohibits such retrospectivity. Let us be clear, the Supreme Court ruled that covert video surveillance involving trespass is unlawful now and has been unlawful in the past. The court was clarifying the law, not making new law. Only parliaments can make new law. I say this because there's been a lot of talk from the government about the Supreme Court changing the law as previously understood or it being in common law. That is not correct. The New Zealand Law Society's submission to the committee agreed with the Law Commission's 2007 paper on search and surveillance powers, saying, quote, "The paper correctly assumes, in accordance with the previously decided case law, that covert camera surveillance which involves trespass to land will be regarded as unlawful conduct." National and Labour Party members say the Law Society was out of date and that there was subsequently, quote, 3 Court of Appeal decisions that we are advised affirmed the lawful use of such surveillance, end quote. That is trespassery surveillance. Respected lawyer Stephen Price says that 2 of these 3 cases, Gardner and Fraser, were not about trespassery surveillance at all. So Labour and National are relying solely on the Court of Appeal Operation 8 ruling, which was overturned by the Supreme Court. That National and Labour could get this so wrong is another reason why it is such a travesty of parliamentary process to so abbreviate the Select Committee scrutiny of this bill and rush it through Parliament. The Supreme Court decision was not some rogue decision that Parliament had to overrule in haste, as we're doing today to the discredit of Parliament. It was a perfectly just decision. Now let's look at the fundamental substantive issue in all of this for the people of New Zealand. That is, in simple terms, do we want to give a range of state agencies the right to enter our homes and, without us knowing, put a camera in our living room or bedroom which can record and transmit our most intimate family activities? Or do we want such a camera put covertly in a company boardroom? The police, in their submission, indicated that they have already done this, even though there have been no reports of such a case coming to court. The Greens say now, as we did in the Select Committee report back on the Search and Surveillance Bill, that putting a covert camera in someone's house or office is a step too far and is not justified by the perhaps 1 or 2 extra criminals it might catch. The Greens do allow for covert video surveillance without trespass. Note the previous 2 Labour speakers. The Greens do allow for covert video surveillance without trespass, say to monitor people entering a house where pee is being produced. But it has to have all the controls that are in the Search and Surveillance Bill on special surveillance warrants, reporting back procedures and tapes being subsequently destroyed, and after the fact, people being told they've been under surveillance. None of these controls are in the Video Surveillance Bill. Why not simply wait until February, when the now fine-tuned Search and Surveillance Bill, with all its controls, is debated in Parliament? Thank you.
Mr. Speaker.
Rodney Hyde.